Thank you so much, everyone from the Quattrone Center and all of you guys for staying so late in the day. This is amazing. Now it's especially amazing that you're going to listen to some scientific lecturing at this time of the day. So I appreciate your attention. But today I'm going to talk about a paper that I wrote with some statisticians out of Johns Hopkins University and some other schools. The paper is, the preprint is on arXiv. I have a link to it at the end. But it's titled Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons. So I'm going to explain what that means. So thanks, John, for the introduction about the government review. So yeah, in 2009 and 2016, the big National Academies and PCAST reports came out. Both of them concluded that the field of forensic firearm comparisons had not been demonstrated to be scientifically valid. And this includes both comparison of cartridge casings as well as comparison of bullets. Since these reports were published, there have been new studies performed. These are called black box studies. There have been a lot of these. And what I'm going to tell you about today is that with this group of statisticians, we've been evaluating the way that these studies were designed, and we're going to provide some recommendations for future studies. So just to give you a little bit of background, my training is as a statistician. I work in the Criminology department at Penn, also with the statistics department. And I teach a class on this in the Crim department for undergraduates. And so I'm going to try to give you some of the slides that I give to the students to tell them about why these things are important. I also have been testifying in court as an expert witness in the field of statistics about the statistical validity of conclusions in forensic science. And so a lot of my work is, it's scientific. I've been doing a lot of the work in my lab, but I also spend a lot of time trying to communicate some of these scientific ideas in a way that makes sense to non-statisticians, lay people, people in the courts, etc. So yeah, these reports found that firearm comparisons were not scientifically valid. What does that mean exactly? So for a method to be scientifically valid, it requires a couple of things. So the first thing is that it needs to be an accurate method. Another way of expressing that is how close is the conclusion that is given to the truth. This is where error rates become important. So things like false positive and false negative error rates, they evaluate the accuracy, as well as the measure of uncertainty about these error rates. So that's where things like confidence intervals, p-values, error bars become important. And then there's consistency. So a method, for it to be scientifically valid, needs to be consistent as well. The way to think about that concept is it giving me the same conclusion every time? There are what I call the two R's. This is from class. But they're the two concepts that people get confused about, but it's repeatable and reproducible. A method that's repeatable is one in which, using the same evidence and the same examiner, they would get the same answer every time. And a reproducible method is one in which you have the same evidence, but different examiners are studying it, and they get the same answer as well. And so that's kind of the requirements, right? We need a method to be accurate and consistent for it to be scientifically valid. These definitions are taken from the National Academies report and from the PCAST reports. They're also just from experimental design from basic science. So yeah, accuracy and consistency. Why do we care about these things, right? I think sometimes it's not evident, and I think actually, John, one time I was giving a guest lecture in your class in the law school, and I talked about scientific validity and accuracy for about half an hour, and I think you said, can you tell us why we should care about these things? And I was like, oh, I thought everyone knew as a statistician, because that's like our bread and butter. That's like all we think about is talking about uncertainty and error rates. But it's not obvious to everyone why this is important. So here I have a picture of two bullets. So the bullet on the left of a comparison microscope is a bullet found at a crime scene, and the bullet on the right was fired by the suspect's firearm under test conditions in a lab. And what a firearms examiner does is look at these two images under a comparison light microscope. This is a two-dimensional image, and they compare the striations from one bullet and the other, like we see on TV all the time, and try to see whether they're similar enough. Maybe not all the striations will be identical, but maybe that's okay. There's some random variability in shooting a firearm, and so the examiner has to subjectively decide whether they're similar enough. And they have to answer the question, were these two bullets fired by the same firearm? That's their task. They can give three different types of conclusions. Either it's an identification, which implies, yes, they were fired by the same firearm. Elimination, they were not fired by the same firearm. Or inconclusive, I'm not really sure. And if we don't really know, what does this mean, an identification? If an examiner says, these are an ID, if we don't know how often human examiners are incorrect about their conclusions, then we don't really know if we can trust their conclusions. And I think this is a sensitive point in forensic labs, because the word incorrect can often imply misconduct or non-compliance. So when I've spoken with forensic examiners, I say, well, sometimes you make mistakes, right? And you might not get to the right answer when you're doing a comparison. They say, no. I've followed all the rules. We have these standard operating procedures, and I'm working extremely carefully. I'm very detail-oriented. I've done nothing wrong. You can't say that I've made a mistake, right? And I'm like, okay, but that's not really what I mean. This is not really about non-compliance or ill intent. It's a question about the uncertainty of the method. In statistics, we always talk about methods having uncertainty. Like any machine learning algorithm, any method is not going to be perfect. And our whole job as statisticians is to quantify that uncertainty. And we don't really expect it to be perfect, right? We don't expect to have perfect certainty almost ever. Right? Quantifying uncertainty is seen as a good thing. But for the forensic examiners, it can be a sensitive point. So I just wanted to clarify. It's just about, we just want to know how often they're wrong. And if we don't know, then we don't know if we can trust when they say that there is an identification. So that's why scientific validity and these measures of accuracy and consistency are so important. So what we did in this very recent paper that we submitted last week to a journal, but the preprint is online, is that we reviewed pretty much all the studies available that are testing for scientific validity in firearm comparisons. And we found that there were scientific flaws in them. So these are what are called black box studies. They are studies that have the goal of evaluating a method's accuracy, repeatability, and reliability. These are the kinds of studies that are used to test, to assess these measures in subjective methods. So whenever humans are making a comparison, we use black box studies. It's not the only way to do it, but it's the way that the PCAST report recommended, and it's just a very simple way to study these measures. And so anyway, researchers have run a bunch of these studies. So we did a literature search of such studies. And so this was kind of like just doing a huge search through a bunch of different databases and finding which studies are black box studies that are assessing the scientific validity of firearms comparisons. We found a total of 28 different studies that met our inclusion criteria. And we found that for all of the studies, they have methodological flaws that are so grave that they render the studies invalid. That is, they don't establish the scientific validity of the field of firearms comparisons or firearms examination. So it's kind of like a grim situation, right? It's like even in 2009, 2016, those reviews had said, we just don't have enough studies to say that this is a scientifically valid field. But if we run more studies, maybe we'll get there. And we find that since then, a bunch of studies have been performed, but they're missing some really basic experimental design characteristics, and so bad that the conclusions, we just really can't take them to say that the field is valid. What are these flaws? So I just copied the table here from the paper, but there are things like inadequate sample size estimation. So there was no sample size calculation done to figure out how many firearms examiners and samples of bullets or cartridge cases were needed to achieve the study goals. There's one thing I should say here, which is that to come up with these flaws, we were using principles of experimental design and also guidance from the FDA. So forensics doesn't have a governing institution that says, these are the standards that need to be used to do a study in forensics, right? We don't have like a governing body. The FDA does this for things like randomized trials to test out new medicines or new vaccines. And so they have very specific guidance about what studies need to have to be valid studies. So we use that guidance from diagnostic medicine. So this is, diagnostic medicine is where, doctors they see two images of a brain and they're supposed to say whether, the one has a known tumor and the other one, there's a questioned image, and they're supposed to figure out if that also has a tumor, right? So there's like a diagnostic medicine practice, and the studies are analogous in a lot of ways. Ooh, come back. Slides. Okay. It's a non-representative sample. So this is basically the study conditions as well as the participants and the samples are not representative of the full spectrum of real casework. What this means is that there's no proof or there's no evaluation that the participants who are being studied in these black box studies are representative of examiners in the real world. And so it could be that they're just testing a very small number of very experienced or very high quality examiners or very low quality examiners, right? And so we're getting some kind of skewed answer from these studies. It could be. We just don't have any proof that they're representative. Same with the ammunition. Like, we don't know if the samples that are being tested are representative of real case, or it could be that it's all the easy samples, right? So this needs to be studied. The error rates were incorrectly computed. There's a huge discussion in statistical forensics about this right now. I'll only tell you about this one piece about the inconclusive results. So basically imagine this. You are an examiner. You're participating in one of these black box studies. So you're given a bunch of pairs of bullets, and you're asked whether you think that these are identifications, eliminations, or inconclusives. And the inconclusives, like, maybe some of them just look really hard and you can't tell. One is very damaged, right? And so you're allowed to say inconclusive. So you maybe choose for a lot of them, maybe 30% of the samples pairs, you say they're inconclusive. Well, those are being considered correct in these black box studies. If you take that to the extreme, it could be that an examiner gets 100 pairs of bullets. They say all of them are inconclusive, and they get 100% on the test. So it's like if you were taking any standardized test, you said, I don't know for any of the answers, and then you get 100% on the test. That doesn't make any sense. How we should handle the inconclusives, there's a lot of discussion about that. We have some suggestions about how to do that correctly in the paper. The main idea is that we suggest using likelihood ratios. So anyway, lots of issues with the way the error rates are computed. There are no valid confidence intervals for the error rate, so we don't have a good measure of uncertainty for those error rates. And finally, there are problems with the missing data. There's a lot of item and unit non-response, meaning that examiners just haven't answered some of the questions. And this has not been handled with appropriate statistical methods. Whenever you have missing data, you have to handle that correctly and carefully to get appropriate error rates. So anyway, lots of methodological flaws. These kinds of these studies that we reviewed would not pass like FDA approval. And so we take that guidance from FDA, but also just from experimental design to say, the impact of all of these flaws is going to be that the error rates that we get from these studies are not valid. One more last note about that is that consistency is also problematic. One of the studies shows that different firearms examiners disagree with one another's conclusions 32 to 69% of the time. The study is only testing for false positive and false negative error rates, but if you look at the data, you can actually get this information. And so it's there's very little consistency as well. That would be replicability. So a lot of issues, but we just need better studies is the point. So just to conclude, all the black box studies that we reviewed that we were able to find in our literature search about firearms comparisons were flawed methodologically. And notably, the error rates among firearms examiners, both as a group and also for individuals, remains unknown. We just don't know, we don't know how often they make mistakes. That means that there's still no scientific basis for firearms comparisons, despite all of these new studies, right? Statements about the common origin of bullets or cartridge casings based on the examination of these, what are called the individual characteristics, doesn't have a scientific basis still. And this is important to our system and to how much we can trust the system, right? And so in our study, we provide recommendations specifically for all of the different flaws about how one should run a study correctly with, to test the validity of the way that firearms comparisons are currently done subjectively with humans. We also make some recommendations about how there's a transition towards objective methods. So this is also mentioned in the National Academy's report and PCAST, the two reports I mentioned at the beginning. And the idea there is that there are tons of problems that come up when we're really only relying on humans to make the key decisions in the comparison. And so there should be a shift to objective methods, such as algorithms, to make these comparisons. Now, this is controversial in forensic science, right? Because people feel nervous about, humans being replaced by machines, and what about accountability and so on. So I have some studies, and actually one of them was generously funded by the Quattrone Center, about how, maybe the best thing is not just to replace humans with machines, but instead have a hybrid approach where the humans are using these algorithms to inform their decisions. Maybe we can get to better quality and higher accuracy conclusions in firearms in this way. I think that's where we're moving. And in fact, in medicine, in diagnostic medicine, that's what's happened. Nowadays, doctors will get an image of a brain, and then a machine learning algorithm will suggest boxes for where there might be an area they need to focus on, right? This might be a tumor. And then the doctor makes the final decision, right? So maybe it doesn't need to be just that machines take over. Maybe we can work together with the machines. And so this is, I think it's very important to work on evaluating current work, and I think this can affect the way that exonerations work, right? A lot of the times the humans have made the decisions in the past. They're still doing that work. But in the future, we can start moving towards having these better objective methods. So that's what I work on in my lab, is working on developing these new algorithms that use not just 2D light comparison microscopes, but instead use 3D microscopes and have a lot more information about the firearms and the tool marks, and they actually perform really, really well. And so there's a lot of hope that I think when I started making these algorithms, I didn't have much hope. I thought, there's these striation marks are all random, the ones, what are we going to be able to say about same source, different source? But now that I have the data, I'm actually there's a lot of information there. Very good classification accuracy with these algorithms that are trained on experimental data. So that's what I'm working on now in my lab, and I have like hope for the future. But at least for now, what we know is the current method is not scientifically valid according to these definitions. So that's all I wanted to say. So this first paper here in bold is the one I presented today. There's the QR code to find it there. That's the preprint, so it's just on archive. There might be like typos in it, you know. We're still like, it really just got posted last week. And then, you know, just have a bunch of other references kind of supporting what I was talking about in validity and accuracy and so on. So yeah, thank you very much. Yeah, let me like get out of here and get him back. Should we make him like full screen?
Yeah, let's see if we can do that. Okay, that works.
Okay.
All right. Thank you, Maria. That was terrifying. So, Radley, you've written extensively about a lot of the challenges in forensics. I still use your multi-part bite mark series to teach that bite marks are not a thing as far as evidence goes. So, given what Maria has just shared, what's the state of then the admissibility? You know, talk about the legal challenges that you've written about in ballistics given this.
Yeah, so I'm glad you brought up bite marks because I think it's a good lens through which to sort of assess the odds of you know, the courts taking this important scientific research that Maria and others have done and, you know, apply to the legal system. And what we found, you know, I think bite marks are a good lens to which through to sort of assess the probability of the courts taking this seriously because, for one, even more so than with ballistics, we know every single scientific body that's tried to evaluate bite mark evidence has found no scientific research to back up the major premises that you know, skin is capable of recording human dentition, that all human dentition is unique, or even that bite mark analysts, you know, even if both of those things were true, that bite mark analysts would be any good at matching bite marks to human teeth in the first place. None of those things are backed by any science. So even more so, I think, than ballistics, it's an even more dubious science. And every scientific body to look at it, again, has found no scientific underpinnings for those premises. And yet, well, let me back up again. One other reason I think bite mark analysis is a good way to look at, a good lens through which to look at ballistics is that with bite marks, you know, because bite marks are inflicted with human teeth and human mouths, oftentimes they have left behind DNA that can be tested. And so when we have these bite mark cases from before the DNA era, and we've gone back and tested the DNA, this is where we found a lot of exonerations and wrongful convictions. And I think Chris African at the Innocence Project has a list of these, but I think we're up to 36 cases in which someone was either wrongfully convicted or wrongly arrested and was later exonerated by DNA, but they were convicted or arrested because of bite mark analysis. The scary thing is that with ballistics, you don't have DNA in a lot of these cases, right? If you are convicted because of forensic firearms analysis, it's probably because there wasn't DNA, right? Someone was shot from a distance, and the odds of DNA ever clearing any of these people are pretty slim. And so if we can look at a similar sort of pattern matching field and say, okay, well, how have the courts done when it comes to actually catching up to the science on this, we can get a sense of how difficult it's going to be for a more difficult field to establish the lack of scientific research like forensic firearms analysis. So the first bite mark case that gets decided by an appeals court where they assess the reliability of the evidence is a case called Marks, M-A-R-X, in California in the 1970s. And that court doesn't really assess the scientific validity of bite marks. Instead, they just say, we're not even going to do a scientific analysis. We're just going to say this is sort of common sense. And we, you know, jurors can just look at this and match it up and say, yeah, that matches. And what happens then is subsequent appeals courts start citing Mark's decision, but they cite it as if it did do a scientific analysis. And so it becomes this kind of game of, The legal version of the childhood game of telephone, right, where one court cites another court cites that court, and pretty soon, this original decision where a court just kind of weirdly just says, oh yeah, this is just common sense, you don't have to do a scientific analysis, turns into multiple courts have now ruled on the scientific validity of bite mark analysis. Within 10, 15, 20 years, you have this formidable wall of case law stating that this is a legitimate field and this is backed by science. The interesting thing about that is that, when courts look at these cases, there's a kind of fundamental tension between science and law, right? Law is always kind of looking backwards, right? We want law to be consistent. We want to establish case law. We want predictability. So we're looking backward for precedent cases, for controlling case law. Science is kind of constantly changing and churning as it acquires new information. And so the courts have been really bad at sort of harmonizing the law with science, even though we've sort of designated judges as the gatekeepers when it comes to good and bad science. And they tend to sort of evaluate these cases like you would expect somebody trained in law, not science, to do, which is that they look at what other courts have done. And so you get over and over and over again, just courts, when asked to do one of these scientific analysis, they just look at what previous courts have done and repeat those mistakes over and over again. One sort of the primary sort of way that prosecutors are able to, and I think Richard will probably get into this a little bit more with forensic firearms analysis, but one of the ways prosecutors can get courts to continue to allow dubious areas of forensics into evidence under both Daubert and Frye, the two kind of standards by which we assess scientific evidence. You have to show that the expert testimony you're going to put on is well accepted within the relevant scientific community. Well, how do you define relevant scientific community? Well, what prosecutors and what some of these practitioners want you to do is say, if you're evaluating forensic firearms analysis, the only valid scientific community is other forensic firearms analysts, right? Same for bite mark analysts. The joke for this is, if you were trying to assess the scientific validity of tarot card readers, you would not limit your scientific community to other tarot card readers, right? You would want people from outside that field, people who, bring different types of expertise and different types of analysis into that. And sure enough, when we look at a field like voice print identification, which is something that was prominent in 1970s and 80s and was eventually found to be sort of scientifically invalid, when judges limited the relevant scientific community to other voice print analysts, they always upheld the scientific validity of voice print analysis. And when they expanded it to include, the general scientific community, they always struck down or would not allow voice print analysis into court. And so that tells you just how powerful it is when you're sort of trying to define the relevant scientific community. How you answer that question is usually how a judge is going to come down. So, as Maria pointed out, we had the DNA study in 2009. We had the PCAST study with bite marks. We've also had the Texas Forensic Science Commission. We had a second PCAST study. We've also had the number of studies on bite mark analysis from the University of Buffalo. And again, all these have come down on the side of there's no scientific validity to this field. But I want to show you, or talk a little bit about how prosecutors have found a way to even sort of manipulate these studies. So one thing about the NAS study from 2009 is that it was very diplomatic, right? The idea was to kind of build a consensus. And so they went out of their way to not sort of declare any of these fields to be, completely dubious or ridiculous. They would say, well, more research is needed before we can say anything about this particular field. And they do this about bite mark analysis as well. And so in one of these cases, there's a prosecutor in Manhattan named Melissa Morgus, who's kind of the champion of bite mark analysis. And her briefs have been sort of cut and pasted by prosecutors all over the country when they're trying to admit bite mark analysis into these cases. And I just want to kind of read you the way she excerpts part of the NAS study and then tell you what the NAS study actually says. So in her brief, she writes, here's the quote that she uses from the NAS study. The majority of forensic odontologists are dissatisfied that bite marks can demonstrate sufficient detail for positive identification, right? That sounds very positive, right? So She leaves out a lot, though. So here's the first part she leaves out. Before that clause, there's the word although, right? That's left out of her brief. And so it says, although the majority of forensic odontologists are satisfied that bite marks demonstrate sufficient detail for positive identification, then she leaves out the next 3 paragraphs. And I'll just read you the first couple sentences to get the idea. So, although, blah, 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 no scientific studies support this assessment and no large population studies have been conducted, in numerous incidents, experts diverge widely in their evaluations of the same bite mark analysis. It goes on and on and on like this, right? So they just excerpt that one part where the NAS study is trying to be sort of somewhat diplomatic and leave the rest out. This gets cut and pasted into court briefs all over the country. Judges then issue rulings based on these excerpts. And I can tell you, to date, every single time the scientific validity of bite mark analysis has been challenged in a U.S. criminal court, that challenge has been rejected. It's been up bite mark analysis. It has a perfect record in the scientific community, which is to say it has never won, and it has a perfect record in the courts, which is to say it's never lost. And it tells you just how bad the courts have been at basically sort of being able to stand up to themselves and admit that they've made mistakes in the past. This one kind of blows me away. As of today, there are 4 states, Mississippi, Wisconsin, Connecticut, and Texas, 4 states where the controlling case law determining that bite mark analysis is a scientifically valid field and should be admitted into evidence of criminal trust. The controlling case is a case where someone was convicted because of bite mark evidence and was later exonerated by DNA and is now considered innocent. So if you're a defense attorney in one of these cases and the prosecutor wants to admit bite mark evidence, they're going to cite to one of these cases because that's what they have to do, and that person is innocent. And the fact that that's what controls whether this evidence gets admitted, I think, is pretty remarkable. Just to give one more example of sort of how prosecutors and law enforcement have kind of manipulated these studies. The author of the NAS study was a federal judge named Terry Edwards. And after the NAS study came out in 2009, again, we saw over and over again prosecutors would say that the NAS study, at no point does the NAS study say this particular field should never be admitted into evidence. And the reason is that wasn't what the study was for, right? The study was to evaluate the existing scientific research and sort of basically kind of build a consensus toward reform, build a consensus toward doing more research, right, and finding out what is and isn't scientifically valid. But the fact that they refuse to sort of categorically say this particular field, should never be admitted into evidence, prosecutors have seized on this and said, well, there was this big scientific study, and if they thought that this field shouldn't be admitted, they would have said so, right? And because they didn't, they're practically endorsing it anyway, right? And so you see this repeated in prosecutors' briefs in court case after court case. And after just about a year, Edwards is fed up, and he gives a speech in public where he says, that isn't what I was saying at all, right? Stop, taking my words out of context. Stop taking the NAS study out of context. And yet they continue to do so. So if we go back to forensic firearms analyst Jim Agar, who's the general counsel for the FBI Crime Lab, just in a law review article a couple of years ago, again, cites Edwards and cites the NAS report and claims that because the NAS report never said that the forensic firearms analysis was invalid, it must be valid, and it must have been a sort of a tacit endorsement because they didn't sort of condemn it. I guess just the last point I want to make to kind of just put a cap or a punchline on how infuriating this can be. One thing I've noticed, I've been doing this for about 20 years now, and a couple years ago somebody sent me a recent ruling from the Nevada State Supreme Court. It was on a bite mark case. And in this case, the bite mark evidence, the evidence that this guy was guilty was pretty strong, but the bite mark evidence was used to get him the death penalty, right? It was one of the aggravating circumstances that led to the death penalty. And a guy named Ray Rawson testified for the state, and basically he said that he could not only could he match the bite mark to the dentition of the defendant, but that he could tell that the bite mark had been administered before death and that it had been particularly painful, and therefore it constituted torture, which is an aggravating circumstances, which gets us to the death penalty. Whatever you make of that, okay, you can evaluate that on your own. Because this guy brings a post-conviction claim in, I think, 2016, and he says, he cites all this evidence that bite mark evidence has been discredited by science. And the Nevada Supreme Court issues an opinion where they agree with him. They say, yes, it has been discredited, but they say it was people were discrediting it or criticizing it way back in 2005, 2006. You should have brought this post-conviction claim a lot earlier. You have missed your sort of window in which you can bring one of these claims to challenge the validity of forensic evidence. Well, in doing that, they cite some of my old articles that I wrote back in the mid-2000s. And for me, it's just kind of infuriating, right? Because people did bring challenges to bite mark evidence back then, and the courts rejected them. And, as most of you probably know, in post-conviction law, if you bring a claim and it's rejected, you can't bring that claim again. And the problem in forensics is that there's never a point where the scientific community all sort of has a vote, right? And they raise their hands and they say, this field is now invalid, and now every prisoner has 1 year to bring their post-conviction claim, to challenge this evidence. The courts never say, the Nevada court never said when it changed its mind, and that's the particularly infuriating part, is that among the courts that rejected challenges to bite mark evidence way back when was the Nevada Supreme Court. And in fact, 5 years before that decision, a couple years ago, they rejected a challenge not only to bite mark evidence, but to Ray Rawson, the exact same state's expert witness. Rawson has actually put 2 innocent people in prison, 2 people who were later exonerated. And the court rejected that challenge. So somewhere between 2016 and 2022, the Nevada Supreme Court changed its mind about the validity of bite mark evidence and of Ray Rawson in particular. But it never told anyone. It never told any of the people sitting in prison who were convicted because of this evidence. It was just up to them to sort of know that the court had now changed its mind and bring their claim within a reasonable period of time. This also happened with my work in Mississippi with medical examiner Stephen Hain, who I've been writing about for years. In that case, the Fifth Circuit, a federal appeals court, within 18 months, they rejected somebody who had challenged the credibility of this particular medical examiner. 18 months later, they said the medical examiner was now discredited, but it was now too late for anybody to bring a claim. So within 18 months, you have 1 year in federal court to bring a claim, based on new evidence. Within 18 months, this court had changed its mind, but never told anybody. And the particularly aggravating thing about that is they cited an article I wrote for Reason magazine back in 2006. So basically, the court was telling this guy in Louisiana who was pro se, representing himself, that from his Louisiana prison cell in Angola, he should have been aware that this tiny libertarian monthly magazine with a population of about 37,000 had published an article about Stephen Hain by me, and he should have known about that in 2006 and brought his claim within a year, even though those same courts were rejecting those claims. I think the work that people like Maria are doing, and particularly with the 3D imaging, I think, is really promising. The problem is the courts just haven't been very good at keeping up with the science. And I think our law and our sort of system of laws in the justice system in general has been sort of designed in a way that, one, it makes it very reluctant to admit its own mistakes, but also just sort of by the nature of law, we want consistency and finality, and that often, conflicts and directly kind of butts heads with science.
Okay. So this brings us to you, Richard. And, I'm kind of reminded by, Maria, of your talk by the Princess Bride, when they say inconceivable, you keep using that word. I don't think that word means what you think it means. Like ballistic science, right? You keep using that word science. I don't think it means what you think it means. And we've heard from Radley about all of the structural reliance on the past, and certainly forensics, ballistics is much more widely used than bite marks. And so we can't let go of bite marks as science, even though they're conclusively proven as not a thing. And then we get to the case of Illinois versus Ricky Winfield, and you decide to take a swing at the admissibility of ballistics.
Yeah, hopefully modeling the sort of title of this symposium, I'll be able to do a little bit of Anguish and a little bit of action sort of mixed together. So I'm very, very fortunate to come from a large public defender's office in Cook County, Illinois, Chicago, basically. That was, I think, the first in the United States to do something which has borne a lot of fruit across the country, which is to say, listen, most lawyers get into the practice of law to flee science and math, right? Maria mentions competence intervals, and lawyers plug their ears, or they start sweating, or just leave the room, right? But if forensic science is going to be an increasing part of how crimes are prosecuted in the United States, at least some quotient of lawyers have to get over that. And so my office started what it calls the Forensic Science Division, which is a team of now 8 attorneys who, even though we might not have backgrounds in science and math, I'm an English and history major, are dedicated to focusing just on those issues, litigating their admissibility, doing cross-examinations, and the like. So when I started in that division a little over 8 years ago now, we had never dealt with firearms examination evidence. It wasn't one of the disciplines that we believed we had any competency in, and so my boss essentially gave it to me and said, figure out if this is worthy of being in court, and if it isn't, please, handle that, get rid of it if you can. The Anguish part of this is that it is really hard to do that, right? Judges, like attorneys, have very little scientific understanding, so they are confused by and don't want to engage with really complicated topics. They want to hear, there's 28 studies. They don't want to hear, for example, the rest of what Maria has to say about why those studies aren't doing what we think they need to do. And that's compounded by, sort of what you were just mentioning, John, which is that if you go to get rid of something like firearms examination, you are getting rid of a field that has been in our court system for a century and that has been used to convict at least tens of thousands, if not hundreds of thousands of people. And so you're really asking for the legal system, not just to say, we messed up in this one particular case, hey, we're a good system, but we got it wrong when we exonerated this person. You're kind of forcing the legal system to say, we aren't very good, we don't work very well. So when I was given this sort of project and began litigating it, I think we were perhaps even the first office in the US following the PCAST report to say this stuff doesn't belong in court, it has not been demonstrated to be scientifically valid. The Anguish part is that we lost a lot. I filed a 60-plus page motion attacking the validity of this field 18 times and lost 18 times before the case John mentions, People versus Ricky Winfield. It took an incredibly special judge, one with a reputation for sort of bucking, not the law, I think he was eminently right on the law, but for bucking norms, right? For being willing to say, I will look at this scientific field despite the kind of costs to the criminal legal system, giving us a chance. And I would be really remiss if I didn't mention that it required other people all across the United States who have done really, really good work. So in Illinois, our standard for whether you can obtain a hearing on the general acceptance, we're a FRI state, of a particular method is there unequivocal and undisputed support for the methodology in the scientific literature or in legal opinions. So if you don't have, or if you have that, you can take judicial notice and let it in. If you're missing that, you have to conduct a hearing. In other words, the judge has to see for themselves what's going on. They have to listen to people like Maria talk about the science. And Winfield was not the first to say this field is not generally accepted. So attorneys with the Public Defender Service in DC litigated a case called United States versus Tibbs and largely won, got any testimony individualizing, saying this is the gun, kicked out of evidence, and along the way got the judge to say this field is not generally accepted. And attorneys with the Legal Aid Society and the Bronx Defenders in New York in a case called New York versus Adams got basically the same result. So those are the cases that got us in to court in Chicago to litigate about the admissibility, the validity, and as Maria says, the accuracy and the consistency of the field. And so because we owed so much to these other offices that had come before us, and one, we felt it was incumbent on us, with the size of our office, the budget we have, to essentially expand upon the challenge. And so by the time all was said and done, we had called 4 live witnesses to testify. David Fakeman, who is has a lot of training in statistics and in research, who's the dean of the University of California, San Francisco Law School. Dr. Nicholas Skurich, who is a quantitative psychologist out of UC Irvine, who was sort of one of the very first people to mention what Maria called that sort of inconclusive problem. Dr. Jeffrey Salyards, who has basically run every forensic thing a person can run. He's as deep in to the other side as one can get. And then he's sitting somewhere back there. There he is, raising his hand. Dr. Jeffrey Kukuka, who also a psychologist, to talk about cognitive bias. We also had affidavits from another 5 professors and doctors in statistics for women who are statisticians associated with CSAFE, as well as a fellow named Dr. Thomas Albright, who is a neuroscientist. So you had PhD after PhD after PhD, all these different disciplines coming together for the defense. On the side of the state, right, this has been around for 100 years. Surely you could find somebody who, as Radley said, isn't a tarot card reader themselves, right? Just one. Especially because in all of our briefing, we said, I bet you, Judge, that they won't be able to. Like, let's put it on the money now. Let's put the money on the table now. That won't happen. The state called one witness. That witness was a career firearms examiner, has no training in any science outside of firearms examination. And ultimately, for a lot of reasons that I could be here for 30 minutes talking about why no one should listen to that particular witness, but was found not credible by the judge, who essentially decided this guy has been manipulating data and misrepresenting the scientific record for the field. And the conclusion was that no testimony at all. The firearms examiner in our case could not appear in court at all. And so it was significant in that regard. So I think, the anguish part is this is really hard to do. We have not won again since in Illinois, despite that unequivocal and undisputed support standard, despite the fact that we did a 5-day hearing and just sort of wiped the floor with the prosecution. We've kept losing, right? Other folks have kept losing, but there are now, by my count, 8 judges across the United States who have said that firearms examination is not generally accepted. That's more than I'm aware of for any other scientific methodology in the history of the United States. So this is now the most rejected thing that has ever come in as science into a courtroom. 6 of those judges that have said, not generally accepted, have gone on to completely exclude, meaningfully at least, kind of individualizing testimony. And another 3 have at least sort of limited the kind of testimony so that you can't really say it's the gun. You can just sort of say it's kind of maybe possibly the gun. So defense attorneys, with the incredible assistance of so many brilliant people like Maria, like Jeff, have finally begun to sort of win these challenges. So the lesson, I think, is you need attorneys, you need resourced offices. Almost all these wins have come out of offices like mine with forensic science divisions. You need the scientific community and really smart members of it to say, I'm sure Maria would have better opportunities for fame and fortune doing something other than nitpicking the studies of firearms examination, but you need them to take a look at this and acknowledge the importance of a field that, again, every year is involved in tens of thousands of cases. It should never have been. It's a real disgrace to the system, and it has cost people lives. At least 7 folks wrongfully arrested or convicted, many of them who faced the death penalty. It should have stopped a century ago, and I think we are at a point now where, for the first time ever with a forensic method, we might beat this one.
So basically what you've done is you've transformed this as the gun to this is a gun.
Right. Yeah, it is in a sense, right? And then you have this whole kind of complicated question of its own about how meaningful that is, right? If all I'm getting is, this is a 9mm and that's a 9mm, when we don't know how many of those exist, much less in a particular city on a particular day, is that useful? But that's less a sort of scientific question than it is a sort of, what judges are more accustomed to, a legal relevance and prejudice and probative.
So one of the questions that we got was about the Fry test, and you mentioned that that Illinois is a Fry state. For those of us here and online who might not be JDs, Can you talk about the Frye standard versus the Daubert standard, what it means to be a Frye state? And this question is, the Frye state has a propensity for continuing to admit problematic. This has evidence in quotes. So what can we do? Is part of the problem the standard that we're using to determine the admissibility of scientific evidence, and how do we combat that in some of these states? So you could kind of cover all that ground.
I guess starting at the beginning, right? Definitionally, there are variations on these, and there are some states that do something different. But in large part in the United States, you have two different standards dealing with the admissibility of scientific and technical evidence. At least the sort of admissibility of the whole of a methodology. You might have kind of application problems, but if you're looking at should firearms examination comparisons come into court, you have the Frye test and the Daubert test. So the Frye test is, as Radley sort of mentioned explicitly, and I kind of alluded to, is the methodology generally accepted within the relevant scientific community? There's a lot of ambiguity there. What does general acceptance mean? No one's really entirely sure. And how might you define the relevant scientific community is a place where a lot of conflict and litigation happens. But that's the standard. And now at this point, a number of years ago, the United States Supreme Court changed. And so the majority of states and on all the federal courts now use something called the Daubert standard. Some people say Daubert, but Daubert basically looks at a series of factors that are trying. I think most of the academics in sort of science and math I've talked to think, sort of reasonably well, trying to capture what scientists themselves think of as the sort of pieces of scientific legitimacy. So it's saying we need to look at a host of factors like error rates, like how well the methodology has been peer reviewed, also if it is generally accepted, and so on. I don't know that the standard is the problem, because there's not really any evidence that Frye and Daubert operate differently. In application, methods are admitted under one, but not under the other, and the like. There's a lot of hand-wringing in judicial opinions, especially in states that have switched over. But really, sadly, the distinction is not between Frye and Daubert, it's between who is raising the challenge. So if you were a criminal defendant, no matter where you're practicing, Frye or Daubert, you're going to lose that challenge. If you are a civil defendant, so if you've got big corporate dollars in your pocket, you have a very high likelihood of winning your Frye or Daubert challenge. So the bias and the problem is less the standard and more who is being impacted by these methods, right? So physicians trying to establish the cause of a particular injury, is it related to this chemical that this company produced? A lot of money behind and a lot of consequences for the courts to say, no, that's valid, that can come in. But the people impacted by forensic science, generally speaking, are poor, they're people of color, they don't have as much of a voice in our system, and it's much easier to say we can, or they can exist on sort of bad science. The example I often give people is I say, many people in the United States have a really terrifying fear of flying. My wife is not here with me in Philly, despite, the free hotel room, because she panics when she goes to get on a plane. But you have less than a 1 in, I think it's 100 billion chance of actually having an injury occur to you when you get on a flight. At best, and for all the reasons we're going to discuss, and for a million reasons beyond that, at best, if firearms examination is involved in your case, like what they will say is, there's only a 1 to 2% false positive rate. Only a 1 to 2% chance that we're going to wrongfully point the finger at you. Who in this room would have flown to Philadelphia if you flew? Who would ever go on vacation again if the airline, when you walked in the door, said there's a 1 in 100 chance you will die on this flight? That number is acceptable only because we are not impacted by firearms examination, by and large, and the people who are don't have the sort of political power to say 2% ain't low, we need to follow FDA guidelines. There are different standards for rich and poor. That's the difference more than Frye versus Daubert.
So it's worth pointing out, I think, so in the mid-1990s, there was a case here in the Eastern District of Pennsylvania called Lara Plaza. And in that case, Judge Pollack issued an opinion that found that fingerprints were not passing muster under Daubert. So the Daubert standard does state validity as one of its requirements. So you know, lawyers were like, oh, it's valid, right? We're not even applying a scientific definition of validity the way that you've done. But if you do that with fingerprints, you similarly run into this same challenge. And Judge Pollack basically said, hey, fingerprints aren't valid under, and therefore don't pass Daubert. And the law enforcement community went, if you'll pardon the pun, ballistic. I'm here till Thursday. So he actually walked that decision back and reissued the decision, taking that out of it, and later said it was his greatest regret as a jurist. And so I just, you know, the part of the issue with the PCAST report, the National DA's Association took the surprising move of denouncing the report before it was actually published. And I think there is this great concern about the magnitude of the challenge that we would have of sort of walking some of the, re-examining some of these cases, which are numerous. So two questions that kind of cover the same ground. And Radley, I think this one is probably mostly for you, but I'll open it up to everybody. You know, why do ballistics get different? Do they get the same or different considerations to other things like handwriting, hair analysis, you know, fingerprints, like other sort of comparative disciplines? Is bite marks the model going forward? Is ballistics the model going forward? You know, why would one be treated differently than the other?
Well, I mean, so far, you know, interestingly, I think, as Richard pointed out, I mean, there have been I guess infinitely times more courts have rejected ballistic testimony as bite mark testimony, right? Because no single court has rejected bite mark testimony yet, even though it's you know, much more easily sort of proven to be dubious. But you know, I mean, I think, you know, one thing that this requires, and I think Richard's right that the judge in his case, you know, was an extraordinary judge who, you know, had a very skeptical view of law enforcement, I think it's fair to say, or was willing to be skeptical of law enforcement. But for a judge to say that this form of evidence that, you know, has really been sort of a bedrock of criminal trials for the better part of the last century, that has put you know, I think it's safe to say tens of thousands of people in prison, that it should never have been admitted in the first place. It takes a judge that is willing to say, you know, I'm working for a system, I've devoted my life to a system that is fundamentally broken. And that's a really hard thing to get somebody to admit, you know. I mean, most people who go into law believe in the law, right? They believe in sort of the rule of law and equality under the law, and they go into the law for very noble purposes. And so for a judge to admit that, I think, is a really huge ask. And I think that's why it's been so difficult to get them to admit, you know, that in any of these cases. I wanted to just add on one sort of similar example to what Richard pointed out about a lot of this depends on who you are. And John, we've talked about this before. I've been doing some work on excited delirium, you know, this condition where people die in police custody, and it's a sort of dubious forensic designation that often sort of gets police off the hook when, you know, they fail to adequately take care of somebody or put pressure on somebody or cause sort of some sort of asphyxiation. And it's been sort of just accepted in the courts for a long time. But then an interesting thing happened. I was looking through legal databases probably about a year ago now, for excited delirium, and I found a number of appellate court decisions where, in civil cases, where the families of somebody who had died in police custody, and that person's death was attributed to excited delirium, filed a lawsuit saying, okay, well, if excited delirium is a thing, if it's a scientific thing, then, and it's been accepted for, you know, well over a decade now, that's something police should be training for, right? They should be able to prevent it. They should be, and if they aren't, then they're negligent, right? And so we should have a cause of action here. And you're going to be shocked to hear this, but suddenly the courts discover their skepticism about these types of diagnoses when it comes to a civil lawsuit against the state or against police officers.
So, thanks, Radley. So, Maria, I'm, you know, Anguish to action, right? I'm encouraged by the work that you're doing, because in part it feels like where Richard and Radley have left us is, you know, they're Galileo, and they're saying, no, actually, the Earth revolves around the sun, and people have a stake in the outcome and are refusing to listen, you're potentially providing an avenue to say, here's a way that this can get done. And I guess my question to you is, with the kind of hybrid model that you're designing, how does that deal with the challenge of human inaccuracies in comparison? So as I understand it, one of the reasons we don't know the error rate is that we don't know how often one investigator gets it wrong versus another investigator, and they may disagree. So you've got like multiple layers of unknown error there. Does your model is there some way to account for our frailties in that model without being completely machine driven?
Yeah, so I think that we don't have evidence yet about where the machine outperforms the human and where the human outperforms the machine. There's some research about that in medicine, and Henry Swafford has an interesting paper about how forensics could learn from the medical field about kind of incorporating these algorithms into the human system and how to adopt those algorithms into comparisons in the lab. But I think, like, I'm a statistician, and so to me it's all about, like, let's collect the data. Let's see what the data says. Like, it could be that for some pieces of the process, the human is much better. And so, like, in that case, let's keep the human making that decision, and then the algorithm might be better at a different piece. And so let's test it and see what's the best approach. There's an interesting article by Karen Cafeter, who's also part of CSAFE in University of Virginia, and she talks about the benefits of algorithms over humans. And there are many. Consistency is a kind of obvious one, because the algorithm can easily make the same decision over and over given the same evidence. Whereas a human, like, for example, in bite marks, there's evidence that they make, and hair comparisons, it has some good papers about showing how the same person comparing the same hairs on different days comes up with different conclusions, right? One day they'll say this is an identification, the next day they say it's an exclusion. And so that's a clear one. There's also the benefit of transparency, or potential transparency, because sometimes algorithms are black box. They're not, we don't know what they're doing, but there's a potential of, showing how the algorithm is making a decision, and if there's a mistake there, that can be repaired. And so there are different, and then also just it's just a little easier to evaluate the accuracy with an algorithm, I think, than with a human. It has to be done carefully too, but and so I think there are a lot of benefits of algorithms over humans, but I do think, like, let's just see what the evidence says. Maybe the humans are better at different parts. There's an interesting, the last thing I'll say about it is, in that Henry Swafford article, he talks about how in medicine, there was an algorithm that was shown to be better than the doctors at diagnosing, I think it was brain tumors or something like that. Just always outperforming the humans. But the humans were resistant to using the algorithm because they felt they couldn't trust it. They're like, I don't know what that thing is doing. I'm just going to make my own decision. And so they just were too suspicious of the algorithm to use it. But the designers of the algorithm found that if the humans were allowed to have a little bit of control over the result, like maybe increase the contrast a little bit, or have some kind of effect on the algorithm performed a little worse than it could without the input of the human, but the humans were much more likely to adopt the algorithm. So they said, like, maybe along the way, like, maybe we can just, like, have the humans mess up a little bit, and that way, maybe that's better, because we get adoption. So I think it's just a matter of, like, trial and error and just collecting evidence to find out what's the best approach. It just requires studies, and I think that's the way forward.
So once again, we're left with humility as the key virtue of improving the criminal justice system. So if everybody could join me in thanking our panelists.